February 2, 2005, a date that AI developers, businesses, and regulators have circled on their calendars. It makes a major shift in the European Union digital ecosystem. The new EU AI Act's provisions on prohibited practices become fully enforceable. Companies across the globe are bracing for possible investigations, fines, and public scrutiny. Today, we unpack what the new rules mean, how come businesses can stay compliant. Benvenuti to Diritto al Digitale, our podcast where law and innovation converge. I'm Giulio Coraggio, a data and technology partner at the global law firm DLA Piper. I'm here with my co-host and friend, Tommaso Ricci, also a technology and data lawyer at our firm, DLA Piper. Buongiorno, Tommaso.
Buongiorno, Giulio. Hello, everyone, and welcome back. Today, February 2nd, 2025, the EU AI Act new provisions on prohibited practices come into force. We are talking about things that are really dangerous. These are crucial rules that every organization deploying AI should be aware of.
Absolutely, Tommaso. I still remember the night of approval of the AI Act where we were following on Twitter, then now
Yeah.
X, the updates around the negotiations of our MPs around the AI Act. It seems so long time ago, but it wasn't. Now the UAI Act has been published, has been adopted, and as you said, the provisions on prohibited practices are directly applicable. The goal of the UAI Act is to create safeguards on fundamental rights, preventing AI from undermining humans' dignity, privacy, and safety.
I remember that night, Giulio. That was a long night, and we were following the negotiations, exchanging messages. It was like watching a Super Bowl match from the US where have to keep up at night, and then the next morning you have to do something else. So, prohibit risks. This is not just theoretical risks. We are already seeing real life cases. We have already seen quite invasive AI solutions of monitoring individuals and their operations on the web over the last months. So this demonstrates that a real scrutiny from regulators is about to happen, and companies need to know what prohibitions they should be aware of in the next coming months.
Absolutely. Just to be fully transparent, the AI office was meant to issue guidelines that would have better clarified the scope of these prohibited practices, but unfortunately, we haven't seen them yet. They haven't been published yet. We have the provisions of the AI Act that nail down what the prohibited practices are. And let's try to go through them as part of this episode. So, number one are subliminal or deceptive AI techniques. It seems something that is quite far from reality,
Mhm.
but we have seen many clients developing solutions that try to manipulate the behavior of, for instance, customers to incline them to perform a potential purchase. Then we have
Yes,
solutions
Giulio,
that
let me up. That's a tricky one because many marketing companies are using neuroprogrammatic languages to try to influence users. So again, here, like that's a subtle difference between something which is totally legal and something which is prohibited, for which high sanctions are provided.
absolutely we've seen solutions that they just consider some keywords and they give recommendations to the seller on how to continue on in the negotiation. That is fine. What is subliminal goes beyond that. Then we have solutions that exploit vulnerabilities, vulnerabilities due to age, disability, or social economic status. Like a financial services app targeting all people with risk investments products, knowing that they might not understand or resist to the big opportunity. I can tell you that my father is called all the time by call centers where they're trying to sell something to him, and he gets furious when they try to leverage the fact that he is old. But if these techniques are powered up with the AI, they become really
Yeah,
dangerous.
yeah, yeah.
Then we have social scoring systems. So AI systems that evaluate people over time based on personal characteristics or predictive behaviors leading to harmful or disproportionate treatment. An example of that would be denying a loan solely because of an AI generated social score gleaned from social media data. And this solution might really be discriminatory and create those sort of biases that need to be corrected, and to which companies developing and exploiting AI need to be very careful. Then we have AI solutions for criminal risk assessment. We have seen many of them on the market. They can be quite useful in detecting the potential source of a crime, but if they score individuals, if they profile individuals and their personality
Hmm.
to detect a potential crime, this goes beyond understanding only the potential criminals behind a crime that was already committed. But the list is longer,
Yeah,
Tommaso.
yeah. That's totally, by the way, that's totally Minority Report. Do you remember the movie with Tom Cruise? They had the three oracles that were able to predict whether you were going to commit a crime, and you were arrested before even getting mad and trying to kill somebody. But yes, we have at number five, we have untargeted facial recognition data collection. So this applies to any types of facial recognition database which is being built by scraping images out of circuit television cameras, or any video camera which is out there, once the collector wants to perform this activity without a proper consent or without a legal basis. So we have seen companies in the past being sanctioned for performing this activity, and their activities were blocked, and they were not just sanctioned by the Italian Garante, which is particularly active, as we know, in the AI scene, but everywhere in Europe and also outside of Europe, such companies were sanctioned. Then we have emotion recognition in work education. So the emotion recognition system are not by default considered prohibited. They are when they are being deployed in specific ecosystems, which is the work environment or the education environment, except for medical or safety reasons. An example could be an AI tool which is scanning student faces during tests to detect stress or fear, or to gauge attention levels and like hint the professors to do something about it.
Yeah.
That's not allowed. Then we have biometric categorization for sensitive traits, which is particularly intrusive. So it's AI which is being used it's using biometric data to infer race, religion, political opinions, or sexual orientation. This is a particular tricky one because it kind of overlaps with another example that we have in Annex 3, which is the high risk AI systems. So they are both considering the use of a metric categorization system, but one is more focused on systems that categorize individually natural persons based on their biometric data to deduce or infer their race, and the other, so the high risk Annex 3 one, is more focused on biometric categorization according to sensitive or protected attributes or characteristics. So you can see that the wording is kind of similar. That's why we have had many clients asking us, what's the actual difference between these two practices? Because the actual difference can lead to a big window in the sanctioning. So these kind of things that fall within the first category, so prohibited systems, they will be totally illegal today, this Monday. Things that fall in Annex 3 will not be legal. They will require an enhanced safety system because they still consider a high risk, but they will not lead to the same sanction. And the last one is the real-time remote biometric identification in public spaces for law enforcement. So that will be live face scanning to identify people in public. Again, Minority Report here, but without the prediction effect.
No, no, absolutely. And this last one actually was the one that was more heavily negotiated during the last hours. I would say before the approval of the EU AI Act between different parties that were considering a priority, having AI solutions powered by biometric data in order to monitor public spaces or during big events, like, for instance, the Olympic Games. And maybe unsurprisingly, we have received many requests of advice during the last months where AI solutions were exploiting biometric data. It is important, this categorization, because the largest fines, up to 35 million or 7% of the total worldwide turnover of the breaching entity during the previous year, are for prohibited practices. So what you were discussing before, Tommaso, on whether an AI solution using biometric data might fall under the high risk category or the prohibited category shows that the right categorization, which is a self-assessment of the company, is absolutely crucial for any business, and needs to be done through an appropriate methodology that should be the methodology of the company. The principle of accountability that we have seen in the GDPR is also reflected in the EU AI Act. But Tommaso, what is your recommendation for companies that now need to comply with these provisions of the EU AI Act?
Well, Giulio, of course, the first one will be to review your AI systems. We just mentioned it. The sanctions are really, really high. It can skyrocket up to 7% of the worldwide turnover, which is even higher than the GDPR. We have seen that it has never happened that the highest sanctions provided for by the GDPR was applied to a company. But yet the fork is really wide here. So I will definitely suggest to conduct immediate audits, especially if you're using biometric data or you're making inferences about user behavior. You need to be able to understand whether a specific practice falls within the prohibited practices or the high risk use cases, and you need to be able to document this assessment, because you will need to be in a condition where you can prove to the authority and to the regulator that you have performed an assessment and you have reasonable arguments to prove why you fall or fall not within a specific category, because the sanction could be high. Then, of course, number two will be ensure data collection transparency. So ensure that your data sources are legitimate and lawful, that you have a strong legal ground for the processing. If you're relying on web scraping, double check if it's permissible. Make your homework, do your homework about having the list of the data sources. If you need to align with the code of practice for the generative AI systems and the general purpose systems, start to assess which documents are required for you to put in place to be able to demonstrate your compliance. And compliance is the queen here, because compliance by design, so AI security, AI safety, and also AI ethics by design are crucial when it comes to planning the AI development within the old company in a holistic way. So embedding compliance measures from the start, exactly as we have seen for the data protection and privacy part, is essential, because it provides a biggest opportunity to ensure compliance, and it's also cheaper compared to if you want to put measures in place after you've done something. So
Yeah.
human oversight, explainability, and robust data privacy controls. And the fourth and last one, I would say, do your risk assessment. This regulation, together with all the other regulation in the digital decade, they are establishing a risk assessment framework. So companies should start to familiarize with the idea that they have to perform risk assessment continuously and try to measure and to monitor the risk level throughout the year.
Absolutely. And this is something that we've been doing a lot over the last months. Many clients submitted to us their AI solutions that they wanted to adopt. These solutions were developed by different providers, not only the big tech giants. And we developed at DLA Piper a solution called Prisca AI Compliance that allows to make this assessment in a convenient and fast way, generating a report that can document compliance to the Act, to intellectual property legislation, to the GDPR, and to the ISO standards, which in many cases have kind of explained and better detailed principles that are embedded in the legislation. But Tommaso, during the last days, I would say, we have heard a lot about a new AI system that seems to be the new kid on the block. Can you tell us about the DeepSeek case and what is about?
Yes, of course, we can say, Giulio, that Italy is again at the center of the war. After March 2023, where all the eyes were pointed to Italy, again, the Italian Data Protection Authority has issued a limitation of the processing order against the company which is providing DeepSeek. So what DeepSeek is basically a large language model, so working exactly as many of the other large language models that we have out there, but the big difference is that it is much cheaper. So companies can switch from the large language model that they are using at the moment to DeepSeek at a fraction of the cost, that is like 1/10 of the actual cost. So it's a huge decrease in the expenses. But the issue here that grabbed the guarantee's attention was, first of all, that the company is based in China. So this is the first big Chinese operator that is coming to the European, and I would say worldwide market, but it's not the only one. I just read that Alibaba has presented its own new model, which is compared to DeepSeek, at least for what I've read so far, is even the performance is better. So again, now we are seeing a new competition, which has started in the US, has moved now to China, and we, Europe, we are sitting in the middle, and we are starting to understand whether this technology can be dangerous or can present risks to our to the data subjects which are based in Italy and in all Europe. And in this case, the Garante, I think there's a pattern here that we can identify compared to what has happened before, because it's the third time the Garante issues a provision against an order against a chatbot. So it has already happened in the past, and there's a pattern of topics which the Garante believes are really important. I would say transparency and having a proper legal basis, having a proper privacy policy in place, which was not the case for DeepSeek. And that's why it also grabbed the attention of many, many commenters and European consumers associations, and then having an age verification system. So three things that are not so easy, but that have to be implemented to be able to operate safely in the European market.
Yeah, that's true. And also we spoke about privacy compliance, even though the topic of this episode was on the UAI Act, because these two areas of legislation are are overlapping a lot. It's not clear yet which authority will be in charge of the AI Act compliance in the different EU member states. It's likely that it will be an authority different from the privacy authority, which would increase the risk of a double fine. So now February 2nd, 2025 has passed. Our recommendations is to do your homework and don't rely on homeworks done by your developer, especially if the company is using an AI solution that is customized on its needs. There is a risk or requalification of the entity using the AI solution that could become directly liable for the compliance of that solution, especially when the practice is prohibited, because at that point, regardless of whether you have developed the solution or you're just using it, if the practice is prohibited, you are breaching the UAI Act and you are going to face all the potential sanctions. So it's not just a question of disclaimers, it's a question of deeply reviewing the solutions and making a proper assessment. We give you some recommendations on how to do it, and hopefully it's gonna be useful.
Yes.
Tommaso, just a few takeaways for our listeners.
I would say, Giulio, looking forward, I would say that like the more groundbreaking the tech, the more intense the scrutiny, and the more you're grabbing attention and going viral, the more you should be aware of the fact that attention is also coming from different ways, and even just from hackers. So I've read that again, DeepSeek was attacked, and I tried to access their website today, and they had a disclaimer saying we are under attack right now, so there's a lot of demand to our servers. Please bear with us. So again, attention can be extremely useful. We are seeing AI going viral and being the big thing in the market. But again, the more groundbreaking the tech, the more intense the scrutiny, and then maybe don't just rely on disclaimers alone. Do you have any other takeaways, Giulio?
No, I think we covered everything. We're gonna run webinars and events in the coming weeks. Please reach out to us at DLA Piper. We're working a lot on this topic. We can give you also a benchmark of how the market is moving in this area and how your competitors are tackling AI compliance. This is it for today. Thank you, Tommaso, for the very useful insights. Thank you, everyone, and just follow us in this on this podcast and on our initiative to know more about this fascinating and at the same time a bit scary, especially for regulators, technology.